Hello, welcome to Rappler Talk. I'm Marites Vitug, and joining us is Justice Vicente Mendoza, formerly with the Philippine Supreme Court. He's a favorite resource person on the Constitution. He appears in the Senate, in Congress, and he is a go-to authority on the Constitution. In fact, the foremost authority on the Philippine Constitution. Welcome to Rappler Talk, Justice Mendoza.
Thank you.
And today we will talk about the draft, the proposed federal constitution, specifically on the proposal to create 4 federal Supreme Courts. And let me just read to you the 4 federal Supreme Courts. Federal Supreme Courts, the first one, a federal constitutional court, a federal administrative court, and a federal electoral court. Will this work? The framers, the drafters of the proposed constitution says it's supposed to lessen, sir, the backlog. Will this proposal work?
Well, if you are just after liquidating the backlog, I tell you, this has been a problem with us for a long, long time, and it has never been solved. I would say because it's a direct function of population, and our methods of work in the court have not improved. That's it. Those account for it. Now, the method proposed in the draft Constitution is to create additional Supreme Courts. And as you said, there will now be 4 Supreme Courts. What is your question?
Will the creation of the 4 federal courts declog or lessen the caseloads of the Supreme Court? But you said it should be the methods of work that should be changed. So what changes should happen in the Supreme Court?
Yeah, because it's not simply a question of reducing the backlog of the court. More important than that is preserving the role of the Supreme Court in a system of government. What's the use relieving the court of its backlog if it loses its soul, its prominence in government, which is what it will cost to create 4 Supreme Courts?
So this will mean weakening of the check and balance system that we have today.
Certainly, the court is able to function as it is today, although much is still to be desired, as a force in government because of 2 things. The Supreme Court is the only court, and it is the highest. Now, you cannot have 4 Supreme Courts as your Supreme Court. There has got to be only one. That's why if you notice in all our constitutions, borrowed from the U.S. Federal Supreme Court, the word is one Supreme Court. The rest are called inferior courts to emphasize the fact that this is the highest courts. The rest of the courts are inferior to that Supreme Court. Now, that's one. Placing the Supreme Court, only one, at the top of a hierarchy of courts to make it really very, very prominent. Number 2, give it the power of judicial review, meaning to say, determine the validity of the acts of the other departments of government. Without these 2, you cannot have a Supreme Court that is co-equal with the political departments of the government.
But in the proposed constitution, there will be a federal constitutional court. And shouldn't this be the most, in the hierarchy of the federal Supreme Courts, isn't this the most important? Or are they all equal?
You're going to downgrade the Supreme Court, but neither are you going to transfer the magic simply by conferring this power of judicial review in the Constitutional Court that they propose. No, the Constitutional Court will not be like the Supreme Court. Why? Because it has very limited jurisdiction. And its jurisdiction embraces cases that are not as important as the cases that the Supreme Court now hears. The power of judicial review must be exercised simply as an incident of those important cases. But just to give you an example, if you carry out the idea in the proposed Constitution, even unlawful detainer cases, popularly known as ejectment cases, which are triable by municipal courts, the lowest in the hierarchy, you cannot file them in the trial courts anymore if they involve a constitutional question. You have to file that in the Constitutional Court in Manila.
So you mean, sir, if there's a constitutional question in an ejectment case, you go direct to Manila?
If there is a constitutional question,
Yes,
I'll
yes.
illustrate.
Okay.
There's a rent control law. You cannot raise the rent more than 10%, I think, every year from the last time it was adjusted. Now suppose the owner of the house demands a higher rent, and the tenant says that that is contrary to law. But the property owner will now say that law, that rent control law, is unconstitutional. It takes property without due process of law. It is confiscatory. It is unrealistic in light of the present cost of construction. So it takes my property without due process of law. So that's now constitutional question. Normally, that should be resolved only in the trial court. They are capable of deciding that. Of course, subject to appeal to the Supreme Court. But now, you can't even start that there. You have to file it originally in the proposed constitutional court.
So it goes against the grain of decentralization or federalism is to give power, sir, to the regions, at least the regions, and the courts there should be able to take care of that issue. So it's inconsistent, sir, no?
Inconsistent. Now, these reforms that they are proposing in the judiciary clause of the draft constitution, these reforms have nothing to do, by the way, with their proposal for a federal system. Whether it's federal or unitary, you can have these reforms, but then subject to those objections.
Sir, are you aware of countries which have like 4 federal Supreme Courts? What is the model for this proposal?
If I'm not mistaken, they probably took this from the Canadian Supreme Court or from the German High Court. But then the question is, these countries do not claim to have a Supreme Court as prominent as the United States Supreme Court. No. The parliament in these countries are powerful. No question about that. But we in the Philippines, where we have patterned our court system after that of the United States, we want our Supreme Court to be a co-equal branch of government with the political. We want it to be equal so that it can stand up and say the acts of the other departments, if found to be contrary to the Constitution, are void. We want that. Now, it's a different matter if you are giving up that idea.
Sir, were you consulted or other experts when the Constitutional Commission drafted these articles?
No. I was never asked.
I see. So are you aware, sir, if others were consulted? I'm just asking because the chair of this is former Chief Justice Renato Puno, and he's aware of the experts in this country. So I'm just surprised that there was no consultation.
I'm not aware of anyone invited by them during the course of their study.
I see. Sir, on another issue, earlier you said, or at least you wrote in a piece for Rappler, that only it will be helpful if only constitutional cases are brought to the existing Supreme Court. How can this be done?
Not the existing, the proposed
The proposed
constitutional court.
No, I'm saying, sir, for the existing Supreme Court without the proposed constitution, how can the existing Supreme Court just hear or deal with constitutional questions when they hear all kinds of cases?
That's it. That's the secret of their strength. That they are not a special court, that they are a generalist court, hearing all types of cases and only expounding on the meaning of the Constitution as an incident in the dispatch of ordinary business. Because if your only job is to look at the constitutionality of the acts of the other departments of government, you might even cause resentment. But here,
yes,
when you say only as an incident in the ordinary course of business of courts, then you're saying it is inevitable. We cannot avoid it, even if we don't want to touch on the validity of your act. We cannot avoid that without taking it up, because it is part and parcel of this ordinary case that we are hearing. It's a generalist court that we have, and that is the secret of its strength.
Sir, when you were Justice of the Supreme Court, how did you manage your cases? You had hundreds of cases per month, if I understand right, sir. How did you manage this, and were you able to, you were able to write major decisions, you were able to handle the cases. So,
I don't think I gave any special preference to constitutional questions simply because that's along my alley. I'm not aware I did that. Only probably that they got mentioned in the papers because they're headline cases. But I think I lavished the same kind of preparation for the other cases. Yeah.
Sir, also, in the proposed constitution, there are, in the Bill of Rights, they're mentioned, aside from the social and economic, the Bill of Rights includes social and economic rights as well as environmental rights. How do you see the workings of the 4 Supreme Courts in the light of these rights, which will require the courts to demand from the executive to provide resources to implement these economic, social, and environmental rights?
That's right. That the problem is they inserted in the proposed Constitution that provision that the rights under that article are all demandable not from the state, but against the state.
What does that mean, sir? Demandable
Well, that
against?
means you bring the case against the government. You cannot just demand it from the government as a matter of largesse or privilege from the government, but as a matter of right, compel the government to give it to you. Just like you complain against the government if it violates your, let's say, freedom of expression. But you cannot do that in the area of social and economic rights and environmental and ecological cases.
Can you give, sir, an example? You referred earlier to what is supposed to be a landmark case wherein the Supreme Court decided, or rather compelled, executive government agencies to clean up Manila Bay.
Yes, the residents around Manila Bay brought a case in the Supreme Court for mandamus. And the respondents there were the relevant government agencies, Department of Public Works, Metro Manila Development Authority, and others. So the court said, all right, order this and that department to clean up Manila Bay. After a while, the residents were not obviously satisfied, so they went back to the court. And they complained that Manila Bay had not really been cleaned up. In class, I would say the one that cleaned up Manila Bay during that time was not the Department of Public Works, but Ondoy. It cleaned up the Manila Bay by washing ashore the garbage on Manila Bay.
So an act of God rather
Yeah.
than an act of the
So,
Supreme Court.
But if that is a civil or political right violated, you certainly can demand that as a matter of right. The government should redress that wrong. It is the very essence of civil liberties that anyone injured in his rights can complain to the government and demand protection for that rights. You cannot do that in the case of social and economic rights. It is declared that every person has a right to adequate food, to clean air, clean soil, clean environment, clean surroundings. You know very well you cannot force government to do this. It will always say, we don't have enough funds to do this. You have to wait. That's why these are denominated political questions, to place them beyond the courts, because the courts cannot fashion remedies to redress those wrongs. So the result is, if you bring an action to enforce these social and economic rights and rights to balance and ecological, healthful and balanced ecology, you're going to end up frustrated because you cannot really get relief in the sense that you can get relief for violations of civil and political rights. Yeah.
So what should happen to those demandable rights in the proposed Constitution? They should not be in the Bill of Rights then?
Yes. Right now, some of them are found in the Statement of State Policies, Article 2, and in some portions of Article 13. Like, for example, this right to a healthful and balanced ecology, that is stated as a statement of, included in the Statement of State Policies, meaning to say, the state, as a matter of policy, will provide that. But putting it in the Bill of Rights and stating in the beginning that these rights are going to be demandable against the state, you're going to court trouble for the courts. People will lose confidence in the courts.
On another issue, Justice Mendoza, the 4 federal Supreme Courts will all be based in Manila.
Yes.
They will not be in any of the regions. So doesn't that make Manila more imperial in that sense?
No, I don't think that that is a valid objection to that. The fact that they're going to be in Manila. Any Supreme Court must really be located at the capital of the state. Now, because it's the highest court, and the seat of government is there, you cannot complain against that. Anyway, the complaint against Imperial Manila is really a complaint, the all affairs of the Philippines pertaining to, whether pertaining to matters of politics, economy, or culture, are decided here in Metro Manila without regard to the needs of the rest of the country due to centralized government or urbanite snobbery. So that's it.
On,
Not judicial. No. And
yeah.
if you take it up there, then they are against it because you cannot now bring small cases involving constitutional questions like ejectment cases unless you come to Manila. All the more, they will say you are reinforcing Imperial Manila.
Sir, one of the usual or common complaints or observations about one Supreme Court is that it takes so long for the 15 justices of the Supreme Court to decide a case. It takes years. So how can that be reformed or avoided so that the one Supreme Court remains, a credible and effective Supreme Court?
The remedy so far, and this has proven to be effective in the United States, is what they call the certiorari jurisdiction.
What does that mean, sir?
It doesn't mean the ordinary petition for certiorari you read about in the newspapers. No, that's not the one. There are two kinds of certiorari. Now, this one simply says that decisions from the lower courts going up on appeal to the Supreme Court must only be limited to very important cases. Number two, to cases involving legal questions of importance to the nation. Outside of this, the Supreme Court is not to be bothered. Now, so I am for that system. Number two, we have that already in the 1997 Rules of Court. Only that we have not fully exploited or used it. The other half of that is, you do not let these cases be docketed once they are filed in the Supreme Court. You create a committee, screen them to find out which one should be placed in the docket. These should be competent people so that the time of the court will not be wasted on screening out the unmeritorious cases coming from the lower courts. Now, all of this presupposes, of course, a very strong trial court system. Your trial court should be very good so that people will not appeal to the Supreme Court unnecessarily.
So, sir, who will choose the
But if you take the attitude, anyway, this will go to the Supreme Court, and that is what happens. And I think that attitude is bad. I think I'm going to go back to the old adage. Trial courts are created to search for the truth. Appellate courts, especially the Supreme Court, are created to search for the errors. If you take that attitude, give the responsibility to ferret out the truth from the mass of facts of a case, you will end up with very good decision. And all that the Supreme Court will do there will be search for errors that might have been committed by the trial courts, so that its time can be devoted to the development of law in the most profound national aspect. Then you have a real Supreme Court
That's a huge,
that can stand up to the political departments.
that will be a huge challenge, sir, for the Philippine Supreme Court.
Yeah.
And the screening committee and the criteria will all be set by the Supreme Court.
Yes, yes.
And this screening committee is not composed of justices? Can they just
You,
hire...
better if you can get retired justices to do that. Maybe you can do that.
Has that been ever attempted in the past?
Not in the Philippines.
Okay.
In the United States, that's the practice. Yeah.
So, sir, on that note, there is a hope for reform in the Philippine Supreme Court?
Certainly there is, short of increasing the number of Supreme Courts.
Exactly. So there are...
Four Supreme Courts, neither one will be a Supreme Court.
so
Neither one will be. All of them will just be
ordinary
courts. You're going to reduce them. And you're going to impoverish the judicial process on the whole.
And there will be so many justices of the Supreme Court?
You don't need too many because
Four, like
there are
15
9.
for 4?
It's a proposed Supreme Court
Ah,
composed of 9
9,
members.
okay.
9 members. And then there are going to be 4 of them. So how many will that be?
36.
36. You don't need that number.
It will, as you said, impoverish the judicial...
The whole judicial process, the quality, what I mean in simple terms is the quality of the decisions will be much lowered.
On that note, Justice Mendoza, thank you very much for joining Rappler Talk. And thank you very much to our listeners, to our audience. And we hope that this discussion continues not just among lawyers, but among citizens who want real reforms in the judiciary. Thank you and good day.